It gives me immense pleasure to introduce my erstwhile college senior, good friend, and top-tier lawyer, Mr. Siddharth Raja, who's a specialist in commercial and corporate law, venture capital, then foreign exchange, mergers and acquisitions. He is also a very keen historian, who's, I think, worked on the history of Mysore. He also conducts walks around the Nandi Hills and all. So, unlike, I'm sorry to say this, unlike so many other corporate law people I know who are essentially one-dimensional, Siddharth is not, right? There are so many sides to his personality, and this is where things become very relevant, because you see, many of you are thinking of joining a law firm, especially a corporate law firm, right? This thing started when we were there, right? When I was my first year, Arthur Anderson came with, do you remember Uncle Arthur, as we used to call him, the huge packages, right? By the time we graduated, things became more, huge packages became the norm rather than the exception, right? So a lot of people got into this, a lot of people, could not take the pressure. Some people took the pressure, some people also, like Siddharth, developed other interests. So what I'm trying to say is that, like every other branch of this profession, this has its positive sides and its negative sides. And I think, we all think you guys need to be informed about all these aspects. And who better a person than than Siddharth? So, may I request the Honorable Vice Chancellor, Professor Venkat Rao, to present the memento and speak to us.
This, sir, I was just about to say, this you should give this to me after my speech. In the sense, if I don't say nice things. Thank you. Come. Thank you so much. Oh wow, that's nice. Alright. I wish this would go on. Thank you. Thanks.
Just 1 minute.
Sure. Much appreciated.
Friends, this is an afternoon with a difference for me. Because my mind goes down the memory lane to that jewel in the crown of legal education, National Law School of India, to Bangalore. We always say the alumni of National Law School of India University are a deferred dividend. And the manifestation is here, Siddharth Raja. And whenever I look at corporate law, I'm fascinated by one statement. Corporate should have business brain and a social heart. And Siddharth is the best example of that. Okay, he has a social heart. Okay. But two things always agitate me. Even in 2024, you use the word business in a pejorative sense. How to really justify it? People say legal profession is not a commercial profession, it's not a business.
It's a practice.
Can't you equate business with service? Remember, is it time that the dignity should be restored to business? Please think about that. Because after 250 law firms, according to Stephen Harper, the author of the book, The Lawyer's Bubble, 250 law firms control the entire legal profession in the United States. Yes. And therefore, why should we continue to use it pejoratively? Number one. Number two, is there a need for us to have a relook at professional ethics, taking into consideration the emergence of corporate law? Now, professional ethics, misconduct, Advocates Act, they were all done with a view on litigation advocacy as such. But now it's only a part of the profession. Now has time come for us to have a look at it and The last point I'd like to say is, I don't want to stand anymore between you and Siddharth Raja, because the taste of the pudding would be always in the eating. You will enjoy it. Okay? And this is the beginning of many exercises to come. My only request is, actually the memento was to be presented at the end of the meeting here for me. And normally with that, the group photo also at the end of the meeting, but I have another commitment. Therefore, my humble request is, just let's have a group photo first, okay? And then we'll come into proceedings. And then you grant me leave to take leave of you, okay? Okay, that's it. Thank you very much.
Absolutely. Thank you.
ಹೇಳ್ಕೊಂಡ ಓಕೆ
They're all sitting in the back. I sometimes tell my class that I take, come a little closer, I don't bite. Why didn't you come in so that my field of vision is a little easier? There are chairs of thespians, so and part of our training is to project our voice over the tin in court, right? Although I'm not a court-going lawyer, but this is an ideal location. It's a good, damn good place for a nice little play, right? On, the court is in session by Tendulkar, for instance. Thank you so much for coming. Sorry if I've taken you out of your regular classes, then my apologies. But I happened to come into Goa just for the day today, to meet with a few people, and actually to meet with, believe it or not, the only other people that I'm meeting today are all ordained priests, right? So I've met some Jesuits, I'm going to meet one more, not a Jesuit, but another ordained priest, right? And so I'm here for the day, and I reached out to Abik, who's a couple of years junior from law school, only because he wrote to me on some social media post saying, thank you for something, and that you were here. Correct, and that Professor Venkatrao is here, who I didn't know was over here actually. I hadn't realized that. So it's a short trip in and out, and if I might say so, this is to me, this is the best time. This is the best weather that Goa has to offer, if you ask me personally, right? Because it's nice and cool, and even though the rains are there, I like the rains, right? So good, thank you so much for being here. I'm going to talk a little bit about my career as a corporate lawyer over the last 26 years since I started. After, just to give you, and I'm glad the introduction wasn't about what I have done or not done, but I'll just quickly give you an overview because it's relevant to this topic of, corporate commercial law practice, is that I began my career in Bombay, as it was still known then, right? With an old storied law firm called Crawford Bailey, right? A good old corporate law firm. I don't know if some of you have interned in Bombay, but Crawford Bailey is still there, Mondiman Circle. And with two seniors, one of whom I met last evening and had dinner with, who at that time in 1998 had a combined experience of 60 years, right? So Vadia and Udeshi was the man I met last evening. He's just completed 60 years himself at the bar, right? He started his career, actually it's more than 60 years. He started his career in 1958, right? So, well, to some extent that shows you my vintage, okay? So, I just want to spend a minute or two about that start of my career, and I think it's relevant even today. It's only 25 years ago. People in the front row will resonate with this. India was changing rapidly, not perhaps as rapidly as it is today, but it was a new India. Remember, it was only 10 years barely after the opening up of the economy. And in fact, in the year 98 when I started, India was a little bit of a pariah state. If you recall, to Abik's point about providing some historical context to my career, in March or April of that year, India had detonated a nuclear device, right? The then new Vajpayee government had done that. And India had become a pariah state. US had imposed sanctions. And I had just completed my master's in the UK, and there wasn't much to be had in terms of a position in the UK. That, sadly, is still the case. Because if I can give you a little vignette, remember that if you're looking to do anything overseas, within the confines of this room, the United Kingdom, sadly, in some respects, but perhaps in many respects it has earned itself that moniker, is a basket case, right? You won't get anything to do there in terms of work, honestly, as a lawyer. Sadly, there's a lot, they are contracting, but India was the pariah state in '98. And, but at the same time, India had started opening up, and the kind of work that came through the doors of the firm, I moved with the two seniors to another firm that they helped create in '98, '99, called Udvadia and Udeshi, right? Which is, by the way, today the firm known as Argus, right? That it has merged into this firm. The nature of work was a very interesting mix of infrastructure related work and a bunch of investments or mergers and acquisition related work. Now, when I say infrastructure related work, it was essentially contracts relating to engineering, procurement and consulting, right? What is called the EPC contracts. That is, contracts involving the supply of materials and, what should I say, components, etc. for power projects, right? As well as other infrastructure projects like ports and airports. Less so airports, but really the emphasis was on power generation, electricity generation. And so the kind of work there was new, completely fresh, even, by the way, to the law firm I was working at. Right? So it was new in the sense that it was not stuff that had been done by the previous generation of lawyers. The two seniors I worked for had done some amount of such contracting work, but it was usually with government, right? Because the Indian economy was a closed economy all the way back into the 80s, and the early 90s. And so the contracts were kind of already heavily negotiated and kind of dictated by government. But now you had the fresh overseas contracts coming in, primarily from English law firms and some of the New York Wall Street law firms. And I was an interesting set of contracts. I can recall from experience, I was seconded. I don't know if any of you will remember a company called Enron, right? Enron India.
Shadol.
Yeah.
Shadol Power Project.
Dabhol. We were India Council to Dabhol, right? And so I was seconded actually to Enron India, and then also to the Dabhol Power Project. Which of course got into a huge controversy because of the price at which the electricity was being supplied. That the allegation was that the government of India had agreed, and the Maharashtra government had agreed to too high a price for the unit of electricity being produced. It was very expensive, right? But more than the power project, Dabhol was also doing other infrastructure work, Enron. And they were building India's first data center, way before its time, right, in '99. A data center which focused on the, the housing of systems and servers, which has now become passé. But it had a lot of contractual work. I remember we had to deal with all kinds of contracts. And the point I'm making to you is, don't shy away from even the smallest types of contracts, because they all fit into a larger scheme of things. So, for instance, we worked on an agreement for pest control, right, to keep the rats out in the data center, while at the same time negotiating a master services agreement with Wipro for actually running the data center, right? So the heart of the data center was the capturing of data and the transmission of data. Way before its time, 25 years ago, when you had internet speeds at, you could hear the distinct, you know, the whir and the click of in order to click to the internet, right? The 286 or whatever the connection it was.
Connect your modems to your phones.
That's right.
Dial-up modems.
That's right. And you'd get that click.
Yeah.
Right? And so this was a data center way ahead of its time. Yeah, it would keep buzzing until you got the connection. Right? And I remember that because Wipro was in the job of making sure that ran properly, securely, because it had to be a stable connection. You couldn't drop in the middle. And they were designing that whole thing. So the negotiation of the content of that contract was equally important as the rat agreement, right? Because you didn't want the rats chewing the wires, right, in the physical space. Enron, by the way, collapsed in 99-2000, right? And I often derisively say, you know, we have a ministry for skills development today, right? It's called upskilling, right? I always say the only skilling I knew went to jail, right? The chief financial officer of Enron was a guy called Jeff Skilling, right? So he and his boss, Kenneth Lay, both went to jail. And I think Skilling is still in jail, right? 20 years later. Kenneth Lay died in jail for all the fraud that they had done. And of course,
the statute Extra-Rolling came after that.
Sarbanes-Oxley and all of that came after that. That's right, absolutely.
So I had been to US just immediately after that.
Sarbanes-Oxley was a result of that. Today's corporate governance codes in the US, which influence us here, in SEBI codes, etc., is largely was drawn from the experience of Enron.
Yes.
Right? The collapse of Enron and the collapse of Arthur Andersen, which collapsed as a law firm, as an accounting firm, because they were heavily involved in what was a fraud in Enron. Right? Although I should say that in India, Enron did not collapse because of fraud. It collapsed because, and as my senior used to be aghast when he used to tell me this, he said, Enron is failing in India because its largest customer, the Maharashtra State Electricity Board, refuses to pay the bill that it had voluntarily agreed to. Right? An electricity bill was not being paid. Simple as that. Consider that. So you had to, and that's how Enron fell in India, because they didn't pay. And he says, worst of all, was that the contracts had been negotiated in such a way that the purchase of electricity by the Maharashtra State Electricity Board was guaranteed by the Maharashtra government, and there was a counter guarantee from the government of India. Right? So two levels of guarantee. And as you know, the law on guarantee is that if the debtor, that is the person who has to pay the money, the principal debtor, if he doesn't pay his bill, the guarantor is liable fully. Right? In fact, it's a primary liability. Right? And the government of India and the government of Maharashtra said there is a dispute, underlying dispute between the State Electricity Board and Enron regarding the contracted price. Therefore, we will not honor our guarantee, which was taking the law of guarantee and turning it on its head. Because if a guarantor tells you that I will not pay because the creditor and the debtor have a dispute, that the entire commerce will collapse. That the idea behind the guarantee is I will pay regardless of the dispute that exists between debtor and creditor. It's a primary liability and it's a first recourse liability. I don't even need a rejection. I can come to you first and say, I am anticipating a denial of liability or a dispute that he will not pay, therefore you must pay. And India's sovereign rating, by the way, collapsed as a result of that. Can you imagine a sovereign government saying, I am not going to pay, right? Only because the debtor and the creditor had an issue. It was a horrible time. I mean, I can tell you that it showed us in poor light, right? Because subsequently they settled the matter. The Dabhol plant is now run by some state board. I think it's run by one of the National Thermal Power Corporation or whatever. It must be a few hours down the road on the way to Bombay from here, right? In Raigad or wherever. Right? That's on the coast. So that was my first experience I must tell you about over there. I had some other interesting experiences which time will not permit that. But the Enron guys used to be on a 24-hour cycle. Right? So we had to, and that was the advantage that we currently still have. That is, we produce the better agreements, or I should say the cheaper agreements in India for use by the US. It's a good 12-hour cycle. Right? So I have clients, for example, today who come to us because our charge-out rates are much cheaper than what a US law firm, even a mid-tier law firm in the US would be more expensive than us. Right? To produce standard form agreements or general services documents, like for example a licensing agreement or a supply agreement, and we are more effective. That, by the way, is another area of work that may open up more in the coming years as India becomes more like China in terms of its global dominance. We are poised to get there, right? I think we should also be a little circumspect, because China is a good example of what not to do as well, right? So that actually leads me very well, segueing right away, because my next stint that I can tell you a little bit about in terms of my corporate practice is that I spent about 4 years with an international law firm called O'Melveny and Myers, based in their Hong Kong office in the Greater China practice. That was between the years 2001 and 2005. It's a long time ago. I in fact began work on the 17th of September 2001. 6 days, not even a week after the attacks in 9/11. Yeah, and China was, and I think even today, sitting in India, we sometimes ignore the size of China. Right? It was then very important. It is still, despite all that the Indian press will tell you, it is still very important, and will continue to be very important for the sheer fact that you can't ignore 1.2 billion Chinese, right? Just as you can't ignore the 1.5 billion that we are almost today. But I can tell you that the thing about working there, that four-year stint, was largely to do with investments into China, where they actually created a legal system out of nothing. Right? There wasn't a legal system worth mentioning. Today, China has a very robust legal system. If anyone tells you that they don't have the kind of freedoms and protections that the West has or we in India have, well, that's farthest from the truth. Right? The Chinese are not fools. Right? That they may keep political freedom away from their people, but if you ignore China's economic might, you ignore it at your peril. Right? It will continue to be a force to reckon with in the world. In fact, I would go so far as to say, from an experience that I can tell you, is that if some of you even consider learning Mandarin, right? I think it's another option in terms of what you can do. Just imagine, there's one junior of mine, and I think of yours as well, Abhi, who has made it his life's work to learn anything about China, and is actually proficient in Mandarin, both spoken and written. A guy called Santosh Pai.
Santosh Pai, yeah, of course.
He's your batch, isn't it?
No, be my junior.
Oh, okay. So Santosh is a specialist on China, right? Because he's a specialist because he understands the language, and it's a language which actually leads you to an understanding of people, right? It's unlike us in India because of our colonial influence. It's been shrouded over. There are two countries in this world that I think you can learn about their culture and their way of doing business. You have to get into the minds of the Chinese. There are two. One is China, and the other is Russia, right? Which again is a country I don't think that can be ignored. I know there is trouble in the Russian world today, right? But there has been trouble in the Russian world for several centuries, right? And they will continue to do that. What do they call that? Russia is that enigma wrapped up in a riddle inside a mystery.
Yeah, mystery wrapped in
I'm paraphrasing it. I said enigma wrapped up in a riddle inside a mystery.
Churchill said that.
Yes, that's right, because you can't understand the Russian mind without understanding the Russian language. That's another language that I think is very important. It's a way into the way they think, right? And the way they do business. Because Russia, and especially Russia, just again a digression, especially Russia because, there's this sudden movement in India, right? There's a lot of this, the motherland and Bharat Mata and all the rest. I mean, the Russians have regarded Mother Russia as Mother Russia for centuries. Right? There's an inalienable part of themselves that has to do with the land that they were born in. Right?
Rodina they call it, right?
Huh?
Rodina.
Yeah. But coming back to China, these were contracts involving a country, as I said, where there is no rule of law, right? There is what is called rule by law, and let us not forget that, because people will tell you China doesn't have a robust intellectual property protection regime. It doesn't have good trademark protection. Yes, that is true for a foreigner. They look at it entirely from their own perspective. But they have very detailed rules on how to do business, how to conduct business, how to sell business, how to sell products, how to import products. And I think and for that, by the way, the very good aid would be to learn the language itself. Something which I never did, by the way, which is why after a few years I realized that I had to get back. Right? There was, in a team of 70 lawyers that O'Melveny had, myself and my immediate senior that I was working for, an British guy, Patrick Hardy, were the only two non-Chinese speaking lawyers. And I told Patrick, I said, you know what, India is growing. This is 2004, 2005. There's clearly an uplift, to some extent inspired by the India Shining campaign of Atal Bihari Vajpayee, which of course ended in disaster, as you know, right, because he lost power. But that led to an understanding that I need to come back, because there was also great opportunities here. And within a few months of me moving back, Patrick quit as well. And you can't do, China is a country that you certainly cannot do legal business in, right, without knowing the language. So I said, why go through all of that? But with the deep sense of respect, I think we consider, just consider the influence. We talk immensely, again, very one-sided in today's press from whatever I can see, of the influence of the Indian diaspora around the world. The Chinese diaspora are equally important, by the way. In fact, perhaps more important in a country like the US, right? Because the Silicon Valley was actually built by Chinese diaspora, right? And they are the sharpest minds that you could find, right? Don't ever let them on, because you have to. Santosh is a good example. Our foremost experts on China say we really have to understand that country. And by the way, the foremost Indian expert on China is a man much maligned and much sidelined today. There's a gentleman called Subramaniam Swamy, right? He's actually an expert on China, right? Apart from being an expert on Pakistan, and of course several other things that he calls himself an expert. But these are two things he does have an expertise on, for sure, right? So that was when I came back in, and I think it was a time when I got back in. My talk, by the way, it says itinerant, kind of wandering. So I moved back, initially thinking of being in Bombay. I was in Bombay last night, and I always tell this to many juniors. There's no better place, by the way, to start a good commercial law career than Mumbai, right? Except that it is one of perhaps the worst city in India to live in. Yeah? I know I might be hurting some of your sentiments here, but yesterday was a horror story. I was driving back at about 7 from near VT towards Central Lower Parel to get to my old boss's home. It took us 45 minutes, and it was just a nightmare set of traffic. All the old mill lands have given way to these high-rise buildings. As I was telling someone this morning, one chawl has been replaced by yet another chawl, right? Except that you don't have workmen, you have fancy cars, right? Which is the same idea, that you're living on top of each other like sardines in a tin. And but it is the best place to begin one's career. I wouldn't swap the 4 years I worked in Bombay for anything else, because it ground you where it needed to, right? I'm an early morning person, so I used to, much to the astonishment of many of my colleagues, would get into the office at 4 in the morning, right? Because my brain would stop by 8, right? So walk down onto many of the eateries on DN Road, have something to eat, have a quick drink, right? One drink, which is an old English habit, right? Even if it's one beer or whatever. and head back home and come back at 3 in the morning or 4 o'clock in the morning, because that's the best time of the day. I believe it's still the best time of the day to do any good work, right? But Bombay is truly, my intention was to work in Bombay, but living in Bombay is, sadly, has gone from bad to worse, unfortunately. Many Indian stories, many Indian cities suffer from that. But I think the very nature of the work, the kind of hard grind Bombay continues to be, which at 24 or 25 is the place to cut one's teeth. And to take a leaf out of what Professor mentioned, Professor Venkatrao, that idea of, it's a practice, right? We are no longer a service, right? It's, the council in Delhi will tell you, I've never worked in Delhi, right? So I will not offer, because if you start opening me up on Delhi, then there's another can of worms over there. But they say the practice of the law is a noble profession, right? Partly the reason why seniors in Delhi, for instance, pay their juniors less than what they pay their drivers, right? Because that's the kind of value they associate. This is horrible. But I think in Bombay epitomizes the fact that we've become, as the corporate commercial practice, truly ours is a practice of the practice, because we have to be there along with the commercial folks who want to get a deal done, right? So I think that's the point I want to make about Bombay. Getting to yes, which is, by the way, a book on negotiation, right, by the 2 Harvard professors, which is a good book to read, right? Getting to yes, that is, we shake hands on a deal, rather than getting to win. Getting to win is what Delhi is obsessed with, right? Because you have to win in court. But in Bombay, the only way you can do business is if you strike a deal. And striking a deal necessarily means compromising, right? Because you can't get your entire way, nor will the counterparty get his entire way. You have to reach middle ground. And you should be satisfied that what you have is legally enforceable, but also commercially palatable. That is, the folks who negotiate those contracts must say, I think we've done something good for the future. Because all the transactions we work on, selling, buying, assets, shares, whatever it is, getting the deal done is important. But for the commercial people, it's what happens after the deal is done. If I buy someone's business, then the more important, the more difficult thing is to integrate that business with mine. How do I manage people? How do I manage technology? Those are the kind of things. So Bombay epitomizes that. And I think, it's where I think you develop the 2 essential tools of trade. The Delhi lawyer's tool of trade, when I say Delhi, I'm referring to the court practitioner. His tools of trade is his or her ability to dissect case law and arrive at a conclusion, and use the case law to support the facts, or distinguish a case law in order to support the facts, right? But I think the tools of trade in the corporate world, is a combination of discretion and judgment. Now, discretion not in the sense of what you may have been taught in constitutional law. Discretion to a Delhi lawyer is to be curtailed, right? Because arbitrariness has to be curtailed. But discretion is the ability to choose. And that, by the way, is the fluidity. The brilliance of the English language is its fluidity and its greatest bugbear, because you don't know how and where these terms are used, right? Like, for example, the word, sorry, I'm slightly digressing, but discrete, spelled R-E-T-E, as opposed to discrete spelled with double-E-T, right? So it's just the fluidity. When I say discretion, to one it means exercise of power, arbitrariness, reasonableness, curtailment. But in the commercial world, its discretion is the ability to choose. Where can I exercise that discretion to believe that a particular outcome is more important, even though it's less than ideal, than the ideal outcome? Because sometimes you'll never get to the ideal because you have someone preventing you. That's one. And the second, I think, sorry, what time is it? I should keep.
No, it's too.
I should just, I should stop it a bit. But yeah, so I'll spend another 5 minutes and then we'll throw it over. The other thing, as I said, is judgment. Now, judgment again to a commercial, what do you call it, a litigating lawyer is that of a court, right? Spelt with DG, MENT, right? I'm talking of with the E in it, judgment. The ability to take a call. It's the counter side of discretion, right? You choose because you're exercising your expertise and experience, believing that this is right from what you've seen and what is likely to be. Now that future casting, we all wish we had hindsight, right? As they say, hindsight is 20/20, but it is always behind you, right? There's the famous lines from, I think, one of these English poets which says, you know, what is the use of a lamp? That is what history is, by the way. The lamp should shine a light on the future, except that we place it at the stern, at the back of the ship, to cast light on what has already gone, right? So I think that if you take that analogy a little further, is as I tell my class sometimes, if I knew then what I now know, then I would have acted differently. But sadly, we don't have that. Right? We don't have that ability. That ability that comes, therefore, with years of experience and I think years of learning. Keep yourself open to that, right? You know, different situations will lead to different judgment calls along the way. I then moved to Bangalore, and I'll wrap up here because I want to end on a slightly more quasi-pessimistic view. Okay? Because I think it's a warning to each of you. I moved to the technology capital of India, the Silicon Valley of India, which truly has become that in the many years now that I've been there. Now I've been back in Bangalore from 2006, so it's almost 20 years, right? And Bangalore has seen a huge boom in the quality of entrepreneurship and in the levels of innovation that we have managed to provoke because of the liberalization, right? That has been there now for 30 years. Let's not forget, and I say this deliberately, that we have seen an expansion of the Indian mind positively, the growth of thinking, of doing things differently, of not becoming a doctor or an engineer or a lawyer, but of becoming more than that. We've seen that through 33 years of economic liberalization. We've always had political liberalization, right? We always had that, right? Even in the darkest days of the emergency, you had some lights that you could follow, right? Of course, L.K. Advani famously said to some newspapers when Mrs. Gandhi, Indira Gandhi lost, right? Said, she asked you to kneel, you chose to crawl, right? Think of that, by the way. Today's media is perhaps worse, right, than that, by and large. Independent cells and independent stuff that's coming out is very important, I think. But I think this 30 years of liberalization on the economic front, and I say this deliberately, enhanced and created and enhanced by governments of all colors, center left, coalition, no coalition, minority governments, left of center, extreme left in some case, and then extreme right, and now right of center again, has created this. Let us not forget that. That I think is very important, that, you know, it takes both a Jimmy Carter and a Ronald Reagan to result in what America is today, right? Whatever way, right? You had the moral leadership of Jimmy Carter, who, by the way, is still alive at 100, right? And you had the economic strength that Ronald Reagan, right? I mean, the man stood up in, sorry, I'm digressing slightly, but he stood up in an audience that was largely European and said, that is the evil empire, right, across the Iron Curtain. That's the evil empire. Now, I don't think many people will have the guts to say that of Russia today, right, as that. But, so I you know, this technology thing I was saying, and I'm going to really end on these two. What are you going to do after you finish up here in the next few years? To my mind, there is a huge world of legal technology entrepreneurship that is beckoning. And consider the possibility that instead of joining X or Y law firm or joining X or Y chambers, that you can do something meaningful in the vast, I mean it's like it's the start of the dawn has just broken on legal tech, right? It really has. And it requires young minds to apply. I'm over the hill, brother, right? I'll be 6 feet under in not too many years, right? But this world is out there. And there's so much of interesting innovation that is taking place in legal tech that many of you here will do well for yourselves and for the companies that you start and run. I'll give you one example, just one example. Right? As I said, quasi-pessimistic. I'm coming to the pessimistic one last. Right? It's linked to what I'm just telling you. I had two juniors of ours, class in 2023 from the National Law School in Bangalore. Right? Graduated last year. I had taught them a course 3 years before, online, most of it. Sadly, I didn't meet them in person, but I developed they had kept in touch and they graduated last year. 5th year National Law School, 23, 24 years of age, approximately, right? Today they run one of India's, I would say, leading legal tech companies, right? I mean, they feel embarrassed if I tell them that if they hear me now, right? They are able to apply what they have learnt as lawyers, along with a keen understanding of technology, to help offer solutions that can write documents, review documents through systems, artificial intelligence, machine learning, right? And that's the way of the world, by the way, right? I don't understand it, right? AI to me is, I don't know, it's boggling. But they are able to review, draft, and reconstruct a document through a machine. And more importantly, they can look at 25 existing agreements and do that system that they've developed produces an analysis of those 50, 60, 70, 50,000 documents in the span of minutes. That's what they've built through dint of hard work. By the way. Artificial intelligence is founded on human intelligence, right? It has to be built on someone's sharp brain ultimately, right? And the sharper the brain, perhaps sharper the output. But it's able to crunch all of that volume of documents and do an analysis. I actually had them come to a class I taught a few months ago, and they did a demonstration of this, right? And there was pin drop silence after the few minutes it took to produce that. It produced a report. It said the legal risks involved are A, B, C, D. The issues, the gaps involved are X, Y, Z. Comparing the two, conclusions are this. Now that is a piece of advice that a machine has generated. It took me 10 minutes to read through it. I made a few corrections. I said, hang on, I'm not going to trust this machine implicitly. You have to read it. It took me a few minutes and with my experience I made a few changes, but the machine got it 95% right? And the class was silent. Because I looked at all of them and I said, do you realize that all of you here, because of that machine, at the start of your careers between A0, the first year to the third year, are going to be rendered irrelevant if this catches on? To which Vasu, the guy who's done all of this, Vasu and Darshan, said, no, Prof. AI will replace a lawyer? No, AI will not replace a lawyer. AI will replace the lawyer who does not know AI. Right? And that's my semi-pessimistic way of putting it across to you. The law job today, large firms have cut back on their hiring at startup levels, at fresher levels, because they have machines that can do the work. And they've invested in it. Firms like mine, we're slightly below the radar, we're slightly behind the curve in terms of technology adoption. We still rely on minds, but as a firm, we're only 50 lawyers across the country. You take any of the large firms, some of them have crossed 1,000 lawyers. They used to recruit 50, 60, 70 people, perhaps more. In the years to come, that number will start to shrink. Right? Actually, it may well happen from this year onwards. Right? Except that it will not replace the person who knows the AI. That's my thing. So, you want to look for a traditional law job. I don't mean to sound doomsday. It's not Armageddon. right? And you might say, what the hell am I to do therefore, right? I think you need to understand the way in which this artificial intelligence is going to work, who it's going to impact, how, and start to understand it, start to learn about it, and perhaps become entrepreneurs. The best way, the US is the example of this. The Silicon Valley led the way. The only way to create jobs, right, in the market is to actually create the businesses that will create the jobs. Right? And that is not going to be your steel making and your shampoo producing businesses only. Right? It's going to be all of this new technology. I was looking at that and I said, wow. I mean, if I was 20 years younger, I'd be seriously scared by this. Because it, how, and I'll end on this. How can you become having the discretion and the judgment and the experience? How can you have an experience of a fifth year if you don't go through the first 4 years, right? And if the first 4 years are spent in some mediocre positions, then you are not a capable fifth year lawyer. We find that in a number of times, I'm saying this openly, we find that with the number of applications we get at fifth and sixth years, they know less than some of the juniors that we get applications, right? Because they've simply not gone through it. Sadly, they've not gone through a grind, thrown at the deep end. You've had abusive seniors, let's face it, let's talk about it, right? They're abusive seniors. Abusive in the sense, I mean, I'm not talking of physical or mental, they're just pained souls, right? Something agitating them, right? God knows. They haven't met their targets, they haven't, some of them are consuming 1 bottle more of whiskey more than they should every week, right? And it's a big issue. And I've heard this, by the way. Just yesterday in Bombay, we were interviewing someone. I want to move on from my current firm because every day I get shouted at, right? Now, of course, to which I also said, yeah, but it's part of this woke culture that merely because someone shouts at you, you think you failed. But he says, no, I agree, sir. I appreciate that. Sometimes it's a wake-up call. But every day there's a new complaint. And it's not as if I'm not doing the work. I mean, I am. But different perspectives. How am I going to get that perspectives if I don't experience it? So anyway, I'll end on that by saying, it is a market that, by the way, is contracting. Maybe the market will, like with everything else, will go up and down, right? But I think it calls for an understanding of these new trends, right? Never forget, not all that can be learned can be taught, right? So your law schools are not going to do this for you. You have to seek, right? It's the only way to do it. Seek and enhance, have conversations. And I'm hoping that these conversations that I just did, and I'm happy to now take questions, happen more with this university, of which I'm very happy, and thank you. Good to meet Professor Venkat Rao today and all of you, and especially a week after many years. But yeah, I'm hoping that this is the start of a good university. Thank you.
It was a wonderful presentation. The points that you made about Chinese and Russian are very well taken. I just want to say one very quick thing about the the threat of AI, right? Now, obviously, this is it's something that concerns a lot of us, being redundant by the time we graduate. Recently, I read this article that when AI machines, these algorithms, are fed data generated by human beings, they generate a lot of very useful results. But when the same algorithms are fed data or data sets generated by AI, they result in complete gobbledy. Right? I'll share the link. What I want to
say
that
is in other words, garbage in, garbage out.
Exactly. Right? So what I want to share with you people is that ultimately, as Siddharth so cogently pointed out, people who are behind the curve will definitely become redundant, but people who are ahead of the curve, now what
curve do I mean here?
Yeah.
The whole point is artificial intelligence still cannot think for itself. Be at, for example, when I was in Orissa, right, I used to fight a lonely battle setting open book exams. In ILR, open book exams are the norm.
Oh,
it's the
very
mainstream, right? The whole point is what we are consciously trying to get you guys to do is think for yourself and think systematically, right? Do that. I believe, and I'm sure Siddharth agrees with me, that this fate of redundancy will not befall you.
Yes.
Okay. Questions, please.
Yes, please. Questions, or as
Come to the thing.
Groucho Marx would say, answers. Right? Oh yeah. You should have a screening for them. Have you heard of Groucho Marx? By the way? You've heard of Karl Marx, but you not heard of Groucho Marx? Oh, come on, a week.
Groucho Marx.
Groucho, Chipo, and Hapo.
Chico, Harpo, and
Chipo, Hapo.
Zeppo, and Gamo.
Have you seen them? Those are the finest comedians that America has ever produced. The four brothers, three or four brothers.
Actually, five.
Yeah.
There was Zeppo would occasionally.
Zeppo. Zeppo, Chipo, Harpo, and
yeah.
Groucho.
Yeah. Have the whole set.
Anyway, sorry, I digress. Please, yes.
So usually the commercial or the corporate practice is viewed with like a platitudinal aspect, as though the nature of work is so insipid that you just deal with a cycle of like homogeneous cases. But me being a person who wants learning to be integrated along with my career, do you think corporate would be a wise choice? Like, is there a scope of learning?
You know, it's a very good, I'm glad, it's actually a very prescient question. I think you kind of hit on one of the things that sometimes drives me also to exasperation, saying, what the hell am I doing? Which is the same BS every day, right? Same agreement, same clauses. My response to that is, there will always be some amount of grunt work, some amount of this homogeneous nonsense that happens, even in court litigating lawyers, right? There is some amount of that. It's probably more in the corporate world because of the very fact that we are not dealing with situations in terms of right and wrong. I think that's the answer that I would give. In court, you're balancing between right and wrong. So you have to hear arguments. The more arguments you can present on your side, the better it is that you will be right rather than wrong. But in the boardroom, if I can use that expression, it's about getting to a deal, and that is a compromise, right, as I told you. Now, compromise essentially involves some kind of similarity, commonality. You know, a clause relating to confidential information and its non-disclosure is true whether you're dealing with the largest licensing agreement or with the smallest employment contract. So that language will remain the same. How do you break that monotony? It is a monotony, by the way, right? And monotony made worse by the fact that you can now rely on hundreds of precedents. There's some precedent to have covered it. You're drafting an employment agreement, the firm or some lawyer will have 3 or 4 examples of that, precedents of that. One thing I encourage people to do, think about this, is to do what I call plain paper drafting. Right? Imagine you didn't have access to anything. And someone says, draft me a clause between a lessee and a lessor and a lessee about what the lessee cannot do with the leased property. Right? Just think about what a lessor wants to do to protect his property. What does he want the lessee not to do? Not to build something permanent, not to damage the walls, not to create a nuisance, not to bring, you can multiply this, not to bring firearms, pardon my bluntness, maybe, not to run a whorehouse, right? And so on and so forth, right? So, and then you come to the expression of it, right? I am involved, and I'll end by saying this. So there are different ways of cutting this cake, right? But the one thing that you would all do well, and I'm hoping we can have that out, please go to a think tank in Delhi, the website. It's a think tank called Vidhi Legal, for legal policy. They have a simple English manual out for public laws. We are in the process, I'm helping them, of getting a simple English manual for contracts, okay, which is a much more difficult task, by the way, because everything is a contract, everything is written in some English or the other, right? To consider that the famous lines of Denning, don't write any sentence which is more than 7 words. Bloody difficult. It is more difficult to write simple. It is more difficult to write simple than it is difficult to write complicated. Right? Denning used to do that. 7 words. If you can try, I know you are not an influencer in that sense in the law firm. You are a, at the lower ranks. But imagine if you drafted something which was crisp and simple, rather than regurgitate clauses that you've seen elsewhere, right? That ultimately, who's going to decide? It's the client who says, this is readable, it's enjoyable while reading it, and their only concern is it enforceable? Now that is a matter where we lawyers come in, yes, and probably, I'll be honest, many of the older lawyers, me included, we naturally draft with several I did a clause yesterday, and I looked at it and I sent it out, but I knew for a fact that I wasn't even applying one single rule of English, plain English. I had different subparts to it, different, you have to, the rule is always to lay everything out separately. You have the main proposition, you have an exception, don't use provided. Say this, why don't you actually say as an exception? Because someone will read it and say, exception, okay, or you will say, notwithstanding the above, or regardless of the foregoing, right? Those kind of things. Drop all of that, right? You use it. So I mean, that's where it becomes interesting. You have to make life, and I know you have only a limited scope to doing that, because your senior could well turn around and say, what is this nonsense you produce, right? Look at the forms we've used in the past. It doesn't satisfy any of those. So the moment it is not in, as they say it, not as I call it actually, if a contract is, contracts become holy cows, sacred deities that cannot be touched, right? So they become, we have a word for it. It's called, they are terms of art. That is, you have to turn to a lawyer to understand what is. I'll give you an example. Let me give you an example. Terms of art. Accepts and reserves. You make an accepts and reserves, right? I accept, not accept, accept, E-X-C-E-P-T, right? This is an exception to, and as a result, I am reserving this right. Now, what does that gobbledygook mean, right? What does that all mean? It is separate. You have a main rule, you have a separate rule. You're creating a separate thing. So then call it, main rule as a contrast to or as an exception to the first rule, right? So there are several of these holy cows that will come along the way. You have to touch all of them. You have to kick them all out. But yeah, make it enjoyable as a result. I think there was one more hand up.
Yeah.
Yes.
Katyayani, just introduce yourself.
Good afternoon actually. My name is Katyayani Singh and I'm a second year law student. So first of all, it was an exhilarating lecture. It was very ecstatic, so applause for that.
Thank you.
And my question, I know you ended on that tech and AI part.
Yeah.
So as you know, with the rise of tech,
Yeah.
AI and personal laws like the Personal Data Protection Act, which was also introduced
Yes.
recently. So where do you see the future of corporate and commercial law evolving, particularly in next 10 years? And what skills should we incorporate
Good question.
in our
Very good
daily
question.
lives or even academics that we should focus on?
Okay, great. Thank you so much. Very good question. Please sit, please sit. Yeah. So, what do I see the future? I'm crystal gazing to some extent. I think there's going to be a clear emphasis on the use of machine learning AI to produce a lot of the documents. Right? So even in law firms, you will get documents or memos, etc., that will be machine produced. Now, I think that one of the skills that you should develop, it's not an easy skill, I certainly don't have it, is you should be able to tell a machine developed document from a human developed one. That's tough, right? but I can sense it because of the years of experience that I've got, right? I can sense when something has been produced by a machine. It's staccato, it's too, you know, it follows a particular logic, I think, which says, you make a valid point, however there's another point. I mean, that's very
Cut and dried.
it's very cut and dry. There's something not natural about it, right? Because I think people don't express themselves that lucidly, right? Especially in writing, you know. So that is a skill, by the way, to be able to distinguish. And why am I saying that? Why do you need to distinguish? Because I think that will enable you to focus on, if you can actually develop it. And to some extent, it's a gut feeling. Right? Even if it's a gut feeling, maybe it'll be wrong. But you err on the side of caution by saying, this is a document that needs greater review. I'm not suggesting a human-produced document does not need review. You will obviously have that. But there will be, you know, that will always happen. That continues to happen even today. But that is another skill. How do you then dissect that document, specifically AI produced? It's going to be more of it. It could be anything. It could be an, you know, email communication, memo, client note, whatever, right? Internal memo. All of that is going to be produced by some form of machine. If you start reviewing each with equal rigor, you might simply not have the time. So to some extent, you have to separate the wheat from the chaff. I think a machine learned thing even today, in the next foreseeable future, the near term. In the long term, we're all dead, I guess. And so, yes, right? Yeah, exactly. Right? So in the short to medium term, you separate that which needs this extra review. And the other skill, the only other skill that then applies is your essential, let me say this, jurisprudential skills. Right? You might think it's a whole load of BS. Right?
No, with a big so it wasn't a BS.
Yeah. Thank you. But no, I must tell you, you must go back to those. And you know, they one of my junior, his senior counsel, Aditya Soni, did it very well. First principles are important. You need to know first principles. Those are logical first principles. But as, who is it? The famous American who said, the life of law is not logic but experience. One of them, Roscoe Pound, one of them, right? The life of law is not logic but experience. So you begin with a logical proposition. What is a logical proposition? Let me give you an example. In the law, I'm talking of. So let me give you a legal example. I will give you one from the company law, right? Boards of directors act. Boards of directors act collectively, but discharge duties individually. That's a fundamental principle. Decision making at boards is always a collective decision, but individual responsibility is individual. Now that's a first principle, right? But if you don't analyze the statute, and if you don't analyze the famous cases that are there, the whole series, what does that mean, individually owed? Duty, I know you've not yet done company law, right? Right? So there's a famous principle of duty of, care and attention. Different judges refer to it different. In other words, due care and attention to the company's business. Due care and attention is what standard? Right? By the way, I'm saying this from my many years ago, from law school. Due care and attention is what a reasonable man would do. Right? That's the tort law tells you that, right? What would the reasonable man on the Clapham omnibus do? Right? Right? Or who in law is my neighbor? Right? That's also a rational thought. Right? Donna U. Stevenson, right? Who says he is my neighbor if I can impact his, him. That thing. Now that is, reasonable man is one test. The second, by the way, is what would a person of your particular skill do? So, if the person who's acting as a director, who is a director, is any ordinary employee, he will act like any reasonable man. But if it's a chartered accountant who's a director, then you have to ascribe a greater level, no? Because a chartered accountant knows by his skills what thing. So it's a subjective criteria, right? A lawyer would have better skills. MBA graduate may have a better skill. So you apply that. Now these are all legal principles that I'm telling you, founded on a combination of first principles, case law, statute. Now, while deconstructing that AI document, you have to apply all three to review as to whether the conclusions are right or not. In other words, you need to know let me put it like this, you need to know some essential foundational principles of the subject you're dealing in. It could be trademark law, it could be company, corporate law, whatever it is, insolvency, whatever. But you also need to know a broader range, right? And you should never forget that ultimately issues are determined not by X law or Y law. You may study things in cubby holes, but the real world doesn't act in cubby holes, right? So you have to look at it like that and apply that, right? Knowledge of the law is not the answer. The knowledge of where to find the law is the skill. That you need to hone today. That if you deal with a matter relating to anything, you know instantly which laws that you must go to.
What to look for.
Yeah, and you'll find, you don't need to know everything like the back of your palm, because otherwise you'll never, there'll be too much to learn, right? Right? And every day is a learning, by the way, even for me and him, every day.
And that's exactly why we discourage rote learning.
Correct.
It doesn't get you anywhere.
And you must do more of this open book,
Yeah.
case studies,
We're all on the same boat here.
Because let me just end with one thing. I'll give you an example of this. I'm sorry, I'm just taking a little time extra on this. But I'll tell you a real live thing. Sorry, you have another class? No. Oh, okay. 5 minutes. I once got a memo, a request for a response from a fellow solicitor. That is a Bombay solicitor. I'm not a Bombay solicitor, by the way, although I can claim to be one because I'm an English solicitor. Right? Now, the Bombay solicitor wrote to us in Bangalore, well-known Bombay solicitor, saying, hey, listen, I have a question. A client of mine has asked a certain question relating to the rules applicable in the state of Karnataka, right, about the sale of certain art treasures and artworks. Okay? My first question was, why is he asking me? Or any lawyer? He can do it himself, no? Sitting in Bombay, this is 10 years ago, not as if I'm talking about 90s or something like that. 10 years ago, you have all the Karnataka laws are available, you can look at it. Why is he asking me? Right? And he should do it himself. So, the gentleman on the other side, listen, we have formed a view, right? But I want another view. Now, I remember my old boss telling me that it's the truest honor for a commercial lawyer. The truest honor for a litigating lawyer is to get a fellow senior counsel approach him. Right? This is the truest one, where you have a fellow solicitor who says, I want your view on it. Because I want to double check. Yes, you're double checking. So you already have an answer. Yeah. To some extent, you're looking for confirmation. To some extent, it's confirmation bias, but that's okay. I don't know what your answer is, so I will give it to you. That's true. But you're looking for confirmation. Right? And so the question was this. And a lot of my colleagues' first reaction, it came to the firm generally. Right? It was addressed to a couple of us because that was. But many of them said, I don't deal with this. What are the art treasures, artworks? And they had asked a question about all the famous paintings of these famous Navratna. Well, now no longer Navratna. They were all the well-known. Your Gaganendranath Tagore, Silos Mukherjee, Jamini Roy. Nicholas Roerich. Nicholas Roerich. Right? So they said, I don't know anything about it. I said, listen, I'm a lawyer, damn it. I can read the law and understand it, hopefully. So I'll apply my mind. Right? Now, it was I gave it to a junior. Sorry, I'm belaboring this point to prove what I'm talking about in terms of cross-skilling. I gave it to a junior. They came back with a gobbledygook answer saying, sir, we are unable to reconcile two provisions. Some state act X and state law. I will not bore you with the details. So I said, okay, chalo, let's do it. So I began by reading it and then I stepped back and I said, hold on. You are dealing with art treasures of these 8 or 9 painters regarding the sale and or licensing in the state of Karnataka. What makes you think that the state of Karnataka has jurisdiction? Because they were looking only at state law. So I said, haven't you looked where you should be looking? Which is where?
Parliamentary statutes.
No, which is where? Which is the 7th schedule of the Constitution of India. Who gives the power? Whose authority is it to make laws relating to the subject matter? So they said, and maybe constitutional law, you've studied it in public law. The state list, the central list, the concurrent list. Who has the authority to pass laws? I said because you're looking at 3 state statutes of Karnataka. But is the Karnataka legislature even competent to pass law on this subject? Right? Because if it's not competent, it does not have, what is that famous doctrine? I can't remember the doctrine from the tip of my heart.
Pith and substance.
Pith and substance, exactly, thank you. Right? Pith and substance and questions of authority, power, the actual grant of power. So we looked at the constitution and then I said the answer is now starting to become obvious. Right? Now read. So the Karnataka statutes proved to be irrelevant in this regard. There's a central statute. And why not? And I asked the question, what makes you think that because it's, so by that logic, the central statute should have no implication, right? But this is the remit of parliament to pass the law. So you do that, you don't have to reconcile. So this, you see this? And then you looked at, I said, where is the delegated legislation? I said, now this is administrative law, no? I'm supposed to be a commercial lawyer, right? But I'm telling you essential principles. I know what the principle is. Occupied field, that's the other one. Pith and substance. And those are the 2 that came to my mind at least. Because there's a concurrent list, by the way, item that has a bearing on this. So then we have to look at the role. So we wrote back saying, organization of power begin logically. It's a logical flow, but it's cutting across different areas of law. Do you realize that? Nothing is ever a silo. Tomorrow someone comes and tells you how much is, at what rate of stamp duty do I pay on a lease agreement in Goa, right? Let's take an example, right? Now, everyone comes saying, oh, Goa, Bombay Stamp Act, whatever, I don't know what applies. Let's say, okay, let's forget Goa for a moment, let's say it's in Bombay, right? Oh, Bombay
Goa
Stamp
is
Act.
separate.
There's a separate Stamp Act? Okay, so let's say, okay, there's a separate Stamp Act. But my question again is, where is the authority coming from? Who knows whether the power to stamp lease agreements is a matter for central legislation? Then the bloody Bombay Stamp Act is irrelevant. Someone asked me, but then the Bombay Stamp Act has an entry. I said, it has an entry because they are following a model law, right? They are not, they remember, and there's a reason for it, you'll have a look at it. The rate of stamp duty is a central government subject, rate. But the imposition of the stamp duty is a state subject, right? So, there are several of these things. What makes you, they come to me and say, Bombay Stamp Act says this, there's a conflicting provision. My first response to that is, first response of a lawyer, especially a commercial lawyer, is if there are 2 apparent contradictions in the law, the first thing is to harmonize it, right? The first thing is to harmonize it, no? To rationalize it, right? Because the law doesn't like conflict.
Exactly.
So there must be an answer there. And the answer, by the way, is found in who can damn well legislate on that in the first place. Right? And then there are interesting questions if it's a concurrent subject, then what happens? Does the state law predate the central law? There are rules on that, etc., etc. Right? So, what I'm saying is where to find the law. His open book exam, I remember, my first open book exam.
Anirban Chakravarti's too. We're
Also, yeah?
Yeah,
Okay.
hardcore campaigners for.
Okay. My first experience of an open book exam is the gentleman, our senior professor, Dr. Mitra, that you were talking about, in his own inimitable Bengali way, came into class one day and said, what? Copying? Someone has been caught copying. What copying? I mean, I can't imitate the Bengali as good as well.
I can.
Right? What copying? Best way to avoid copying? You copy more. I'll have open book exam. You copy as much as you want. He says 3 hours, library. In those days, of course, we didn't have any fancy laptop and no internet. 94 or whatever, right? So we went to the library, banking and finance law paper. Jeez, toughest bloody paper. Because you're there You have all this material, and you don't even know where to begin. The guys who went in with notes, I also had some notes. I said, okay, fine. If it's a question relating to this, remember, you're looking at the structure there. If it's a question relating to powers of Reserve Bank of India, okay, this is what I need to look at. This is the provisions, it's there. If I'm looking at if it relates to non-banking financial companies, there are separate rules I need to keep. So you know where to find it. You have some kind of a construct. You're all doing that open book exam, right?
Yeah.
I mean, it actually places a greater burden on the two of them.
Don't they know it? How was the newspaper the other day?
To produce questions that are not simple and straightforward. Otherwise, I could ask, what is doctrine of pith and substance? You can mug it up and go and write something.
Exactly.
But then I have to give you an example through some case or some example, which actually tweaks your interest to remember to write about pith and substance. Sorry, long-winded answer.
That's exactly what we needed. Further questions? Jahek, introduce.
Thank you for the.
Thank you.
Good afternoon, sir. My name is Chehek Pagalia. I'm a 4th semester student. My question is regarding the TMT law practice, which is evolving.
Telecom, media.
Yeah, media and entertainment laws. So with the interface, and when we say that the common operator, which the AI will play and has started
Correct.
playing. So how do you, what will be the trajectory and how do you see the law practice?
I don't, to be honest, that's a very good question, and I think I can tell you right away that I will need to do some reading about the scope and extent of the authority of this common operator. But I can kind of understand what you're getting at, that there will be a platform that will act as, will act for similar purposes for different types of industries, right? So in terms of dissemination of information, knowledge, all of that, data, right? Well, I mean, I think it's a very good area of practice for sure, because I think that what is happening is that there's again some amount of convergence between, there's a convergence in terms of the kind of mediums through which people are accessing information, right? It's becoming more, what's the word for it? I'm trying to explain this. It's becoming more
Ubiquitous?
That is one, ubiquitous, but it's also very private. There's private determination now that enables people to access, right? Because the algorithm is picking up your perceptions, right? I mean, oftentimes I think about it, I'm sure you do as well. The moment I've said something about a particular topic, on some social media feed I have something that pops up. It's almost like, is that damn phone listening to me? There is obviously some, it's kind of tracking your trajectory of what you read, see, listen to. So it kind of puts that same stuff through. Right? To some extent, it's like a echo chamber, sadly. I think that is where control is going to emerge. Because AI is going to play in fact, it's already playing a role.
It has started.
Yeah, absolutely, and it's going to play even greater. In fact, it will dominate it, Because ultimately, if I have written an email, I'm telling you this, I've written an email this morning to someone about, what was it? It was about this new merger control regime that has been operating. So I just mentioned it in some email in passing. And soon enough, on one of my LinkedIn things, it has popped up, saying article on merger regulations or something, Now, I mean, it's a little scary. So there's huge implications for policy, by the way. Let's not forget that all of you here are not going to become commercial corporate lawyers in the sense I have become. You will continue to operate in the corporate commercial law field, but in areas such as policy making. You could join a Vidhi legal center to influence policy making. You could join the government for that time. Some of you might become IAS officers, right? No, honestly, and become part of that from the government's point of view. Some of you could get into international organizations, like, for instance, I don't know what the organization for this kind of activity is, but I'm thinking of say the World Trade Organization, right? Or, those kind of bodies that influence these policies. And let's not forget something. I mean, to both of their credit, some of you hopefully will become good academics.
Yes, I sincerely hope so.
No, honestly, because that is now becoming a viable option.
Correct.
For people in this class. You don't all have to go after chasing those fancy several digits in the rupee salaries for the corporate lawyers, but there are principles of policy, data access. What does consent mean? Let me ask you this question. Let me answer it in the Socratic method by asking you a question, right? Which is, what does consent mean in a data-driven world that you just spoke of? If I have to consent, if the basic rule, now I don't want you to answer, think about it. If the basic rule is I have to consent for my data to be used, like what it is obviously being done, what is the nature of consent? How have I given consent? By just clicking on something somewhere long ago? Shouldn't there be some updated consent, right? Shouldn't there be a more focused consent? I agree to the app, the email app, I might have clicked OK to everything, all that. Do any of you read that? What is it called? Shrink wrap or click wrap? Not shrink wrap. Click wrap. Sorry. Click whatever it is, right? You just say I agree. Does that mean meaningful consent? What does it mean in the data laws? You see what I'm saying? One leads to the other. I think it's very important. This controller, the guy who controls that data, that is the new oil. In 1973, the king of Saudi Arabia waged war on this world by simply stopping the supply of oil, and by increasing the barrel price of the oil from whatever it was by a few basis points up. He held the world to ransom. That is also likely to happen with data, right? Through the access of it and the control of it, right? Of course, the fact that King Fahad was then subsequently knifed by his own nephew and killed, right? Because the CIA wanted him dead is another story. Right?
Just
Yeah.
a follow-up question.
Sure, please.
So there are a lot of actors who are going and approaching
Go ahead.
approaching the court of law regarding that their voices or a lot of all
Deepfakes.
Deepfakes, yeah. So this is one of the examples
Yes.
where the consent is not.
In other words, earlier the meaning of consent. See, to my pre-internet generation lawyer, consent is consensus ad idem, right?
Yeah.
You say, I promise, I accept. That is consent, right? On both sides, right? In fact, the definition of contract is that, no?
Yes.
That the parties agree on the same thing in the same sense, right? That is a hugely different model when it comes to this, because there is AI, there is an interface which is not in front of you. I mean, in the old days, you would actually sign a consent. This issue of continuing consent, merely because you signed up to something at the start when you bought the phone or you signed up to the app, Outlook, for example. I was writing on an Outlook. It's essentially Outlook, Microsoft, allowing someone access in LinkedIn to work an algorithm because of my choices, by the way, right? And by the way, it's no longer just consent of yes and no. It is choice-related consent. Why should you share something with me merely because I clicked on something once, or said something, right? Don't you, it's a scary thought, by the way, because then there's obviously someone snooping around. I mean, this whole surveillance state leads to all these kinds of questions. I mean, these are interesting conversations to have.
Absolutely. Next time you must make some more time for us.
That's true. So I can take one last question before I have to head off.
Good
Please,
afternoon,
good
sir.
afternoon.
Introduce, please.
My name is Talveena Singh and I'm a student of 4th semester, second year.
Same batches.
Yes. So, I believe that one of the field where AI might not have a drastic impact is mediation. There's a lot of emotions, say empathy and patience is required in this field. So I wanted to ask, what is your opinion on the same?
By the way, I'm a certified mediator. I mean, that is also because of 25 years of trying to bring parties together. Inherently means compromise. Please sit. Inherently means compromise. How will AI help in mediation? Probably less so, right? Maybe, you see, there's always greater impact in certain areas comes first before you get there. So, yeah. I would think, And it's a good question, by the way, in the sense that I would also ask a counter question by saying, how would AI help in corporate governance? Right? Now, my answer to that, and perhaps the answer to this question is, AI is changing the way corporates do business, first of all. Let's accept that. Let's not even talk about its legal regulation. The fact that AI today can help a Hindustan Unilever, decide categorically how many bottles of shampoo and soap to send to the nearest shop. That's what they're able to do today, right? Because they've tracked demand. The nearest Kirana store sells more shampoo than it does soap, as an example. So, inventory management kicks in. Why should I give you more soaps when I should be supplying you with more shampoos? That's AI. It's changing the way businesses are run and the way businesses are reacting and responding, right? So, AI is not going to have a direct impact on corporate governance, but if it's going to have an impact on the way in which businesses are run, directors of companies have greater responsibilities, right? Because, I mean, just to take the same example further, what does that mean in terms of the production of more shampoos than soaps, right? Where do we produce it? Should we produce it because there's greater demand in Goa, as an example? Should we set up a plant in Goa, right? Now, all of that has its consequences, right? Does that mean supply chain disruption? Does it mean environmental issues? Where am I going to get those? You see what I'm saying? It can snowball into various things. So the directors are facing the more information people have, the more robust their responses need to be to that situation, right? To deal with it. Same is going to be the case with mediation, right? The truth of the matter is that our system is clogged. Right? Our litigation system is clogged. We have to have alternative dispute resolution. In fact, in some cases, it's actually not even alternative anymore. Right? It is preferred, it's mainstream. Right? You have arbitration, which also has that. Arbitration, like litigation, has that I win, you lose kind of situation.
Binding effect kind of.
It has that binding effect, which naturally means someone is a loser and someone is a winner. Right? But mediation is entirely voluntary, right? First of all, you can withdraw consent when you like, right? You can't do that necessarily with arbitration. I know there are some case laws on the point, but anyway, right? And mediation also is like the consent you can withdraw, you don't have the award or whatever the decision. It's actually not even a decision. It's a negotiated settlement. That means you are party to it. You've agreed to it because you see the light at the end of the tunnel, right? So it's not imposed on you, correct? Now if mediation is seen thus, which is what it is really, then the businesses are, I mean, this is the way forward, right? Conflict. I mean, why talk about contracts? Just look at what is going on in the Middle East, right? The most difficult situation to mediate, right? The Arabs and the Israelis, right? The Palestinians and the Israelis, right? Or for that matter, the Ukrainians and the Russians, right? But it's there. You have to mediate at some point in time. Someone has to step up, right? Someone has to. Ultimately, that is what diplomacy is all about, you know. By the way, I once made the statement that actually some of our diplomats might make better mediators because they're trained in the art of negotiating and conciliating and the rest. Remember, a mediator cannot intersperse his or her view of the thing. That's a bit of a line, by the way, that's getting blurred. Most traditional mediators will say, I won't suggest a solution because then I become like an arbitrator. I want a solution to suggest itself from the parties themselves, because the moment that happens, there's greater buy-in. If the you see, it's also human psychology, right? If the party thinks that the proposed solution has come from him, he will feel proud, right? And that I achieved a solution. By the way, I'll end on this. There's been a very good dear friend of mine, a neighbor of mine in Bangalore, has had a family dispute, right, for 30 years over properties in Bangalore worth several crores and a property on on Worli Sea Face in Bombay, which has worth several hundreds of crores. Right? They've been fighting like animals for the last 30 years. Some court here, some court there. 11 brothers, that is the original family. So they had 8 brothers and 5 sisters. Right? And now each of them have their, so there are about 90 parties involved, 90. Okay? They have finally reached a mediated, negotiated settlement. After years of that senior advocate, the Bombay High Court, sitting them down along with some other businessman family, another businessman who acted as a mediator, they finally have an arrangement. Right? They finally have a solution. Right? That property in Worli Sea Face has been sold for 700 crores. The ones in Bangalore have also been sold. Money has, and now these people are thinking, what did we waste 30 years of our respective lives? Parties have died, some of their successors have died, right? Fighting in court. And they finally reached a settlement, right?
Leak house, Janda is Janda is.
It's the same thing, no? Correct. Does he do a literature, law and
I
literature
want
course?
to introduce it in your senior batches.
Law and literature
It's
course,
on-
good.
Yeah.
Watch some nice movies over here.
I've promised you a couple of movies there.
12 Angry Men.
Well done, man. My cousin been.
Yeah. 12
There is
Angry Men.
Hindi also.
And
12
witness for the
Angry Men.
Or the witness for the prosecution. He's right also. We should not forget the.
There's a Hindi version. In fact, I was planning to show them at a later
Yeah.
point of time. There's a Hindi version of 12 Angry Men.
Yeah?
Yeah.
With whom? Okay.
Pankaj, what is his
Faisla.
name? Pankaj
Kapoor.
Pankaj Kapoor.
Pankaj Kapoor as Henry Fonda.
Yes. I'm forgetting the name. I'll tell you. I'll have to just check.
And the other one is, of course,
Witness for the prosecution.
Witness. No. The other one is Anatomy of a Murder.
Of course.
And the most well-known, One Flew Over the Cuckoo's Nest.
Is that law related?
Yeah, you can. I mean, it's got race and yeah. Anyway, sorry, I digress. So, thank you so much. Thank you.
May I request Professor Anirban Chakraborty to
Hare.
deliver? Thanks.
So it has been a very informal interaction. So I will also keep the vote of thanks very informal. At the very outset, let me just say one very important point. From what he ended, about the anxiety, about the kind of a question mark or concern for lawyers about the future, in some few months back, I was introduced to a book which raises this, and I will say, for my vote of thanks, that's the starting point, Future Lawyer by Richard Susskind. And he says, and I was actually introduced to this book by few of my past students. He has been in practice of law almost same period of time than me. He's about 2 years senior to me. He graduated in 98. As he said, I did in 2000. And I've been in this teaching for about 18 years. So he's carrying that book. That's great.
We got the book.
Yeah, he got that book. So, I have produced some students who have been, I've not been a commercial lawyer or a commercial solicitor. I've been a law teacher, but I've produced a good number of commercial lawyers and commercial solicitors in my about 18 years of career. And some of them who have been quite successful now in being partners in leading law firms, including one who is currently the head legal of the largest taxi operator of the world without having a single taxi Uber.
Uber.
In India, he's head of legal, Mohit from NUJS. He's head of the legal of Uber. So Uber is the largest taxi operator of the world without having a single taxi. Only a single taxi. So that's, makes the point about importance of data-driven world. So Richard Susskind, why I referred, because Richard Susskind spoke about in this book 3 important things, which he says future lawyering has to concern with. The first thing it says that now we are living in a world which is more for paying less. So lawyers have to understand.
Yeah.
We are getting into a world where we have to, think about how do we provide, more services from charging less, which is a big challenge for us because we work in compartments. These law firms, have these various divisions. So in a commercial contract, I know this clause is drafted by this team, this clause is drafted by this team. Especially licensing agreements, I have myself been involved in international licensing agreement. I was part of a team which was only responsible to draft the international dispute resolution clause. So we have to, reconsider how we orient ourselves to become multitasking. Second thing he speaks about is how to adopt the technology to be ahead of the technology. Because he's saying that we are leading to a time when we have this disruptive technology. He uses the word disruptive technology will disrupt our legal profession. And he has started. So how we go ahead of technology? By learning the technology. So one step ahead. So that's it. And the third point he talks about, professional competence being something that you have to raise by, engaging yourself to saying that I'm not willing to say no to anything. Lawyers have this tendency, this is not my domain, this is not my specialization, this is not my area. He gave certain examples, right? I have, in these 18 years, principally teaching in national law schools, and I also started my student life not in graduate but undergraduate program, headed by the same person who founded the National Law School of India, from where such finds have been created, like Mr. Siddharth or Abhik sir, Professor Menon. And Professor Menon, used to say that you should say not no to anything, right? And he said then, what is important for a lawyer, as he said rightly, that it is not to know the law, need to have the knowledge of legal method. And what is legal method? 4 things. First, how to find the law. Second, how to read the law. Third, how to interpret and apply the law. And last, how to write. And whenever I used to teach legal method, as 18 years, the reason I referred Professor Menon said that if you are a teacher of law school, you have to teach everything. So in my 18 years of career teaching in mostly the premier law schools of this country, I have taught almost all except tax. I say about tax only one thing I know about tax, that as it is a unforgivable truth that if you have been born as human, you have to die. So if you are earning, you have to pay tax, and that's it. I don't want to know anything more than that. So other than tax, I have taught almost everything, and partial corporate law, not completely, but partial corporate law. And I have learned this stuff that don't say no. But for a very long time, being a teacher of professional responsibility, I always also add one more thing, which he referred in a different way, but I put it in this way, that you should be also prepared to take the toughness of law. One of another National Law School GEM alumni, Vikram Raghavan, I once invited him. Your batchmate?
Yeah.
Oh, okay. So Vikram, I invited him. No, not here. In NLU, Nagpur.
All right.
So he wanted to speak on constitutional law. I said no. If you have come, you have to speak at least one lecture on how to become a lawyer in this transnational law field, because he was working in World Bank.
Yeah.
And he said that one thing is, when you start your career in a law firm doing hardcore legal work like corporate law work, you may later switch your career to anything. It makes you the tough lawyer, and that is required, right? If you start in a slightly softer area, later on it becomes difficult for you to divert. But if you start, so he said, my biggest advantage of my life has been I started with places where it made me tough to take up, right? So these four things are very important, which is a takeaway for me as now a part of curriculum developer and a professor who has the responsibility to build, that we need as students, as you need to think about how do you shape in your career. As law programmer, law academics, we have to also, and curriculum development responsible person has to also think about how do we design the curriculum which will suit you to prepare for that. Yeah. Right? In 90s, based on which Professor Menon introduced this clinical legal education on a report which was prepared by the American Bar Association. It's popularly known as McRae report, bridging the gap between the profession and the teaching of law. So now we have to again revisit that, and I have started that task. And my main complaint that I think with the current system is three. First complaint is when I see students coming to constitutional law, and when I ask them about political understanding, they say, sir, I have studied in BBA. So I have not studied political science, so I don't know about the political aspect of constitution. Similarly, when I see students coming in tax law or corporate law, and when the questions on accounting and finance, they say, sir, we have studied in BA LLB, so we don't know that part, we know only political science and sociology. So we cannot have that, right? Second, technology is something which is going to be the future. You accept it or you not accept it. But technology integration has not happened to that extent in our preliminary, what we say, pre-law curriculum. It is still like we are teaching sociology, political science, history. I'm not saying they're not important, or BBA courses, but we are not giving that much importance on things like what is AI, how AI works. Unless you know how AI works, how can you think about the regulatory questions of AI or the legal questions which AI has? So I am preparing a curriculum, and I am promising you as part of the UG chairperson of this country, of this university, not this university, that for the first time I am going to submit this recommendation to Bar Council as, and it would be a homage that I pay to my teacher, Professor N.R. Madhav Menon, as I did for creation of National Law School, this 5 years integrated law program, a 5 years integrated law program, wherein we don't say BA, BBA, BSc, this, that. It is a 5 years integrated law. And we will have, say, 2 papers on social science, 2 papers on commercial and business accounting, 2 papers on technology, 2 papers on science, and it will be a true integration, psychology, and it will be called a 5 years LLB integrated program. That's it. Now whether they accept it or not, that's a different issue. When Professor Menon started NLS, he was the Secretary of Bar Council of India. I am only an employee of Bar Council of India. But at least being employed to Bar Council of India, I have that access to at least put it to the members and privately also kind of tell them to influence the thinking. But this is necessary because that is what is going to prepare the law students for the current generation and the concerns that he is saying, the curriculum challenges that we have to address. So I am on that task, and I am telling you, before the next time chairman of Bar Council comes, chairperson of Bar Council of India comes here, it will be ready and it will be handed. I will hand it to his, to him personally. Now, last time I had a discussion, he said once you give it, I will put it to the Legal Education Committee, and I have 3 members in the Legal Education Committee who I personally know, Professor R. Venkat Rao, Professor Manoj Kumar Sinha, and Professor Ranveer Singh. I have worked under them, they have been my bosses. One is my PhD supervisor. So I can personally have the academicians influenced, about taking this matter seriously. So probably this change can happen, right? So I'm on behalf of academic responsibility, as he has raised the concern about how the profession is responding to this and thinking about how to provide the opportunity. As academic also, we have started planning how to provide an opportunity for the new generation in the future of legal profession, right? So that has been the biggest takeaway for this talk. Another small thing I want to clarify, I want to state. I also went to US for a LLM at a very interesting juncture when US was coming out of this 2009 meltdown, right? And that was a very interesting time when I saw a transition of the legal profession in terms of work. So work in transition always is challenging, but scope is there, opportunity is there. So you are also going to go to the profession at a time when the profession is going to go for this transition from regular work to this disruptive or technology based work. And that is something that you have to take. And the last thing I wish to say, the name Siddharth has a very interesting meaning in our Hindi. It says the enlightened one who works towards his aim. Gautam Buddha's name, his family name was Siddharth. Sorry, his main name was Siddharth. And today we had that demonstration of a person who has reached that enlightenment and who has enlightened us. So I think I cannot. I honestly don't have any words to express my gratitude to Mr. Siddharth for taking his time out and coming and visiting, and I hope in future he will continue. And as being head of the internship and placement, it is my also earnest request. These days I am doing that. That kindly please, sir, also remember our students for some internship. I recently met Ekta Bell. So I had a good friendship when I was working in Nalsar with Ekta. So I came here from Nalsar, so I was working at Nalsar. So I recently met Ekta, in Hyderabad, and I told her that earlier I was saying Nalsar students, now I am saying for ILR. So, can you please get some more students? I recently, met one more, NLS alumni, and I said the same thing. So kindly, remember our students and visit us time and time again and enlighten us the way you have done it today. Thank you very much.
Thank you.